morning, Your Honors.
Good afternoon.
Good afternoon, I'm sorry, yeah. My name is Will Halou, and I'm here representing Collier Engineering. If I could, I'd like to reserve 5 minutes for rebuttal.
5 minutes, yes, sir.
Your Honors, I hate saying this when I walk over from that table, but the issue on appeal isn't that complex for us today. The basic facts are there is an agreement that contains an arbitration clause. That arbitration clause requires arbitration of all non-equitable claims that either arise out of the agreement or relate to the agreement. Today we're focusing on the relate to language, and we need to figure out if a retaliatory discharge claim brought by Mr. Martin relates to an agreement, the consideration for which was his continued employment. The agreement itself purportedly states that it governs his employment generally, and the agreement has several provisions related to confidential information, and the retaliatory discharge claim uses that confidential information in its allegations. And the agreement has various provisions related to non-disparagement, and the retaliatory discharge claim contains many disparaging allegations. Your Honor, in short, we would say that the presence of those 4 factors each independently would require arbitration because the retaliatory discharge claim certainly relates to an agreement, the consideration of which is employment. Because discharge, yes.
Confidential information and disparagement limitations, those are on public communication, right? It's not, I tell my boss something to that boss's face that's disparaging, and I would be in violation of it. These are publicly communicated disparagement, publicly communicated confidential information that we're talking about, right?
The disparagement and confidentiality, the confidentiality doesn't have a public limitation to it, but they both certainly require publishing the statement.
Okay, so if the action in this case is one where the actions of the employee, as alleged here, the employee says, I'm not going to buy drugs for you anymore, boss. And the boss then retaliates against the employee for not buying drugs for him anymore by firing him. Where's the publishing that's occurring?
Your Honor, it occurs in 2 places. First of all, it occurs in the actual complaint itself, which is a public document in which numerous disparaging remarks are being made and numerous pieces of confidential information are used. That's the first place. Second place is it's going to occur throughout discovery that'll be filed with the court in a public forum. The third is, and it relates more...
You're not suggesting that this former employee's access to the courts can be limited by this contract?
Your Honor,
in other words, his hands are tied as to what he can say in court?
Your Honor, not at all. I think
that's what I heard you say.
What we're saying is, because of the nature of such information, that the resolution of those claims needs to happen in arbitration. So it is limiting his ability to resolve those claims to arbitration. But Your Honor, that's what all arbitration clauses do. They limit a party's ability to resolve potential claims.
What's going on here is arguably a crime. I mean, if we take the employee's statements as true, and you're saying those are confidential as well.
Your Honor, the allegations that comprise the alleged crime, yes, those would be confidential.
So really, under your interpretation of the contract, this gentleman couldn't even go to the police to report this behavior.
I don't think that was thought of when the contract was drafted, certainly.
Let me ask you another question about
Yes.
the contract. Paragraph 10, the last sentence references a Collier Engineering Company employment agreement and or Collier Engineering non-compete agreement. What are those agreements?
Your Honor, I can answer that in 2 ways. One, there's no evidence those agreements exist in the record for the sake of this court. The honest answer is, like with any other employer, agreements evolve over time, and numerous employees will have signed different agreements. This employee signed neither of those 2.
Okay, so this is really not applicable here.
No, Your Honor.
And that's why in paragraph there's an acknowledgement provision, or excuse me, there's in paragraph 1C about disclosure and use restrictions. It's at the top of page 2 of the agreement. There's a reference to an employment agreement and/or employee non-complete, but entered into on a blank date. And the reason it's blank is there's no such agreements. Okay.
Yes, Your Honor.
I have a question about the consideration in this case. The consideration you're saying is continued employment. That's what he gets by signing this. Section 4 of the agreement, if I'm not following this correctly, this agreement is not a contract of employment and shall not be construed as a commitment by either of the parties to continue an employment relationship for any certain period of time. So how are we squaring the idea that the consideration is continued employment with that language of Section 4?
Your Honor, yes, it's a good question, and it is specific to Tennessee as an at-will employment state. What that provision is saying is we are not creating a term contract. You are not entitled to employment. You are still an at-will employee. But the continuation of employment is different than that. The continuation of employment is sign this or you're fired today. Your consideration is you won't be fired today if you agree to these things. And that's how the Supreme Court read it in the case cited in our brief about continued employment being adequate consideration. Supreme Court struggled with the idea, which is brought up in Appellee's brief, that let's say an employer did that. The employee signed, and then the employer fired them the next day. And you've got this 2-year non-compete surviving clause. Supreme Court, in that case, basically said, that's not what we have in front of us, so we're not going to talk about it. I think important here is this contract was signed in 2016. The employment didn't terminate until 2021. And so there's no argument that there was any bad faith in that context. And so what we see is this is no different than agreeing upon a salary. If the employer suddenly said that $28.60 an hour in this contract, we're going to stop paying you, well, that's a breach and the employee quits and the employment relationship is over. If the employee walks in one day 5 years later and says, I no longer agree to abide by this confidentiality agreement or by this non-disparagement clause, that ends the employment relationship. It is that everyday confirmation your continued employment continues as long as you abide by these provisions.
Is the act of filing a suit a violation of the confidentiality requirement?
Your Honor, and again, I know we all struggle with it, and the NLRB is right now. When you sign an arbitration provision, you are agreeing to a forum, and it does limit your rights that you can pursue in court. The act of filing this confidentiality agreement, if you're going to file something that involves confidential information, yes, you're restricted to arbitration. And I can see why a company would want to do that. Because let's say this were a trade secrets case with an arbitration agreement, and you publicly file what that trade secret is. Of course the employer doesn't want that. And that's why the employer may want to limit it to arbitration, because it's not public. And this is no different than that, just because we're not calling it a trade secret. And to be quite honest, Your Honors, the simplest statement of how this relates, the consideration is his employment. The counterclaim is the termination of that employment. Those are essential elements to both the contract and his claim. Of course they're related. It just seems too obvious. The real question here to appellants is, what does related mean? We'd like to give it its plain definition. In our brief, I'm sure you saw the numerous federal appellate courts have considered the question, and the standard they've come up with is touches upon. And when they describe touches upon, they talk about just how broad that is. One federal court went as far as to say any litigation between these two is probably covered by this arbitration agreement. That's how broad it is, because it uses related to. Now,
isn't the agreement telling us it's not an employment agreement, though, and the nature of the suit is an employment suit? And if
the agreement says just the opposite. It says this agreement shall govern employees' employment, except to the extent you have these other agreements. And there's nothing in the record that says these other agreements exist.
And that's, I guess, where you've lost me. Where does it say in the agreement it shall govern employment?
Your Honor, it's in Section 10 where it's titled Entire Agreement. And it says, unless specifically provided herein, this agreement contains all the understandings and representations between the employer and the employee pertaining to, and then that's left blank, and supersedes all prior and contemporaneous understandings, agreements, representations, warranties, both written and oral, with respect to such employment. And then it's a comma with a whole bunch of with respect to other things too. But employment is the first word before the first comma.
And how do we square that again with Section 4 where it says this agreement is not a contract of employment?
It's not a contract of employment for any specific term. You have to read the whole sentence to understand what Section 4 is trying to say. Section 4 is saying you're still at will. Section 4 is saying us telling you this doesn't entitle you to employment. This is an ongoing, again, the Supreme Court talked about continuing employment. Tennessee, for better or worse, is an at-will state. And that section is saying nothing more than, we're not converting you from at-will to term. You're entitled to leave when you want. We're entitled to terminate you when we want. Your Honor, absent any other questions, I'll reserve any
Thank you.
further comment. Thanks.
We'll hear from the appellee. Good afternoon.
Honors. I'm Michael Clemens, with the Nashville Bar, representing the Appellee, Mr. Martin. I want to give just a brief history of this case to provide some background. As you may or may not know from reading the brief, Mr. Martin had been employed by Collier Engineering for over 20 years when he was terminated in 2021. He had held the position of inspector, which is noted in the confidentiality agreement, for 10 years when that agreement was allegedly signed. I say allegedly just simply because my client has no memory of signing this agreement at all. So then when this agreement was supposedly issued to him and told he needed to sign, this is also 5 years into an arrangement where the president of the company is having my client buy drugs for him, opiates that he doesn't have a prescription for. Fast forward 5 years later, he tells him, I'm not doing this anymore, you need to get some help for your substance abuse problem, and he's terminated. This retaliatory discharge claim of you had me perform an illegal act for you, and when I stopped, I was fired, has absolutely nothing to do with this agreement, which is about confidentiality, non-competition, non-disparagement. This is not an employment agreement. I understand the desperation to tie it into an employment situation because that's where the arbitration clause comes in, and that's what keeps it out of court, and that's what keeps all these allegations becoming public. But as you pointed out, it distinctly says it's not a contract of employment, and although Mr. Collier stated that there was not an actual employment agreement prior to this agreement, there's nothing in the record that actually says that. His clients never signed any sworn affidavit saying there was no prior employment agreement. I actually issued written discovery requests asking for any prior contracts, and rather than responding to those, this motion was filed asking that my client's counterclaim be compelled to arbitration.
Was there any argument made about, this agreement has typographical errors to be charitable. Was there any argument below that paragraph 10 contained a typographical error other than the bracketed language?
I don't recall any language below about the...
But maybe it'd help if I was a little more specific. If you look at the title of the agreement, it says, and under the initial paragraph, it says, this employee confidentiality, non-compete, and non-solicitation agreement. And then if you look at the key language that the appellant relies on here, Collier relies on here, it says, the reason why this is an employment agreement is if you looked at such employment, confidentiality, non-competition, non-solicitation. My first reaction is, well, that's a typographical error. What it really was intended to say was employee confidentiality, comma, non-competition, to match the opening paragraph. But that's not, that would make this paragraph make a whole lot more sense than what's been argued here today, but.
I don't recall that particular typographical error being discussed below. There were, it obviously was discussed below about the arbitration provision in Section 7 including a blank. That was addressed by the trial court. They said it didn't negate the arbitration clause. What I'm really having difficulty with is they continue to say that the consideration for this agreement was his continued employment. And I understand that there's case law that says if in an employment contract, which this is not, future employment can be consideration. Well, this is not an employment contract. So basically what you've got is they came to him, handed him this agreement and said, sign this or you're fired. And if you look through this agreement, it's completely unilateral contract. Collier Engineering is not obligated to do anything under the terms of the contract. I've racked my brain and I cannot come up with a single scenario in which Mr. Martin would ever file a lawsuit for breach of contract against Collier, because I didn't promise to do anything in the contract. So how could he even possibly bring a breach of contract claim?
Counsel, in terms of the related to analysis in this case, part of the defense here, it seems to be, is going to be related to the billing issue in terms of was your client fired for related to misbilling issues as opposed to failing to buy opioids. Does that make it related to confidential information, disparaging, prohibition, or is that bringing in the issue in terms of the defense in this case that's going to arise?
That's exactly what it is. The defense is what they're relying on. I still don't understand the argument of having your employees purchase illegal drugs for the president is confidential information of the company. I mean, this document defines confidential information, and they refer to business practices and billing practices, but I mean, if they want to honestly say a business practice of Collier Engineering is having your employees buy illegal drugs and charge the time to someone else, then, I mean, that's on them to say that, but I can't fathom that they are honestly saying with a straight face that that arrangement is a confidential business practice or trade secret of the company that needs to be protected. And as for the disparagement portion, it was discussed in the trial court that disparagement isn't defined in the contract. I mean, of course, everybody has a general idea of what the word disparagement means, but what was discussed in the trial court was, well, is simply reciting facts disparagement? I mean, they're clearly facts that Collier Engineering does not like and does not want to be talked about, but they're facts.
Why is it that if it arises, the issues arise as part of a defense rather than as part of your claim, why does that push it out of arbitration? And if this case is going to be litigated before the trial court with Collier saying your client was misbilling, your client was engaging in improper actions, not adhering to company policy, overbilling our clients, why isn't that enough to make it something that should be an arbitration under that broad related to concept?
Well, I mean, I believe, again, in that situation, you're talking about what their defense to his claim is. His claim is retaliatory discharge. Their defense is that, no, he was fired for some other reason, or, you know, things of that nature. And they're saying because of what their defense is to the claim, it falls under the arbitration clause. I simply have...
But doesn't that touch upon employment?
It does touch upon employment, but again, this is not an employment contract. I mean, this was just a contract that was handed to him 16 years into his employment, 10 years into his position that's noted herein. I mean, of course, it's going to say in consideration of continued employment, because what else are they going to put? You got to put something. And again, as I said, there's just no obligation at all in this agreement for Collier to do anything whatsoever. I mean, Mr. Martin benefited zero from signing, if he indeed signed this agreement, from signing it. All benefit went to Collier Engineering. You also got to wonder about having an employee who's 5 years into an arrangement where they're being asked to purchase illegal drugs for the president, then being handed an agreement and told, sign this or you're fired, that contains a non-disparagement clause with no time limit whatsoever. It basically says you cannot disparage Collier, its employees, its prospective customers, whoever that is, from now to the end of time. Meanwhile, they can say whatever they want against him. It's not a reciprocal clause or anything of that nature. And
Is this a circumstance where some of the issues that are raised in the trial court do come within the arbitration provision and some do not?
I think some of their claims come within the arbitration. They filed a breach of contract claim for $100,000 against my client. Their contract that they drafted, its language says in Section 9, any action or proceeding by either of the parties to enforce this agreement shall be brought only in any state or federal court located in the state of Tennessee. They get around that by saying, but we also ask for injunctive relief, and therefore we've got a right to pursue that in court. But then they're also going to throw in a $100,000 breach of contract compensatory damages claim. I still don't understand also how that is permitted to be brought in court, but a claim about retaliatory discharge under a confidentiality agreement has to be brought in arbitration. To me, I mean, of course, I'm paid by my client to feel one way or the other. To me, this is very cut and dry. I mean, this claim of retaliatory discharge is completely unrelated to this agreement that they drafted. And unless you have any further questions, I've got nothing further.
Thank you, Mr. Clements.
Thank you.
Mr. Halou, your rebuttal.
Thank you very much, Your Honors. I did forget to say one thing initially, and that is the adequacy of the consideration was never raised below. They're asking this court to consider that issue.
Except in the answer.
Yes, Your Honor, but
I
not.
mean, they say in affirmative and other defense, this agreement lacks sufficient consideration as unenforceable. To me,
Okay.
that puts it squarely at issue. I don't know.
Allow me to rephrase. It was never raised to the trial court related to whether or not arbitration should be compelled.
Okay.
I will say, set that aside, quoting this court in Cummings v. Dorgan, quote, as an at-will employee, Dorgan's continued employment by Cummings was consideration for his execution of the 2004 non-compete agreement. And then it cited Tennessee Supreme Court case. Non-competes are signed for the consideration of continued employment every day. It is the main consideration when you already have an employee and you are seeking to have a non-compete signed after they've been hired. This isn't new. The Tennessee Supreme Court's recognized it. This court has recognized it. I will also say, it's in the counterclaim itself in the record on page 110. If you look at the counterclaim, they mentioned in numerous places about the overbilling for the time spent allegedly buying opiates. And they point to the public investigation of that overbilling. If it weren't relevant, why'd they put it in their complaint? It's front and center. And I'll tell you why they put it in their complaint. For the same reason they've been trying to settle this case from the day they filed it. It's a shakedown. And that's why we want it in arbitration. Because if you can publicly shake us down, well, we might settle. But if you got to do it in private, we'll litigate the merits. And that's all this has ever been. And Your Honors, arbitration provisions have numerous purposes. And confidentiality is a recognized one of those purposes. There was an investigation into some of my clients' billing practices. This was filed after that investigation started to, quote, strike while the iron was hot.
Counselor, is there any authority that you could point us toward that would show that filing a suit constitutes publication, the act of publishing or publication?
You know, I will be honest, I did not look for that, and so I can't point to it today. I can point to the definition of publication, and that's public dissemination. There is no question that a lawsuit publicly disseminates information. On top of that, again, one of the purposes of arbitration is to avoid that public dissemination. We're defeating the arbitration clause if we choose to define it any other way. If the point of arbitration is confidentiality, but then you say filing a public suit doesn't violate confidentiality, well, then you've defeated the purpose of the arbitration provision. And there's no question that companies everywhere are using arbitration for the sake of confidentiality.
If we were to accept your argument that this, the retaliatory discharge claim is related to the agreement, it's important to accept your reading of paragraph 10 of the agreement, which is where you, no, you don't have to.
I don't think it is at all. I think when a contract opens with the consideration for this contract is your employment, that any claim that relates to the termination of that employment relates to the contract. It is so intertwined with the consideration itself.
So even if this was a, let's just say, non-competition agreement, and the consideration again was continued employment, anything that did with the employment is automatically related to the agreement.
Does it touch upon the agreement? That is such a broad standard. Yes, it touches upon the agreement. And it's important to note that non-competition agreements are generally part and parcel of employment agreements. In fact, what you see here is, with the carve-out that we talked about originally, what it's saying is, to the extent you've signed this other employment agreement, this supplements it, doesn't supersede it. To the extent you haven't, this is your employment agreement. That's what that provision is saying. But, Your Honor, I don't think you even need that. If a claim deals with the consideration of the agreement, it certainly touches upon it. That's the standard. I'm not saying it's paramount to it. I'm saying it touches upon it. Your Honor, absent any other questions, that's all I have.
Hearing none, thank you, Mr. Halou and Mr. Clemens, for your arguments. We'll take your case under advisement.
Thank you very much.